For one, the system really is designed to encourage reporting to an extent because you have these mandated reporters. And if there's something where there is any sort of potential child abuse or neglect involved, they're in a position where they can report it and it's out of their hands and they don't get into any sort of trouble. But if they don't report something and then somehow it turns into something, it's on them. They can lose their licenses, they can face criminal charges even. So we have
and I am the host of the reality series TPS The Horror Stories and the new series Meet the CPS Defense Experts.
And advocates.
And advocates, yes, and advocates. And what falls under the name of experts would be attorneys, such as yourself, Brian. So Brian, would you like to introduce yourself? Tell us a little bit about you, where you're from, where you work, and so on.
Certainly. My name is Brian Mayer. I am an attorney. I've been practicing since 2005. I'm currently located in Ontario, California, which for those of you who are not local is about 40 miles east of the city of Los Angeles. I handle pretty much any matters that can tend to affect the family, and that certainly includes juvenile dependency cases, that's CPS cases. I think what I really enjoy about CPS cases, frankly, is it's really different from the practice of family law. In family law, a lot of times it's individuals who are just having custody issues with the other parent of their child. But with CPS cases, there's just a sort of general expectation that the government treats us fairly and does right by the child. And it's a good field. It's a rewarding field in that it's one where the attorney can hold the government accountable, can hold them to the appropriate standard of proof. And certainly, especially when you're dealing with families who are either wrongfully accused of some sort of abuse or neglect, or in cases, or even in cases where maybe the assessment is correct, but the treatment is unfair. It's a good way to step in, and it's rewarding work.
Let me, well, before I start any questions, Vince, do you want to go ahead and introduce yourself for those that may not know who you are?
Sure. My name is Vince Davis, and my office is my main office is in Los Angeles County. My firm practices in a number of areas, and but one of the main things that I do is I practice in the area of juvenile dependency law, just like Brian. I've been an attorney. This December it will be 35 years. And many, many years ago, I was a court-appointed attorney in Los Angeles County. Now, as a private attorney, I represent people all over the state of California, from Shasta County in the north, all the way down to San Diego County, and everything in between.
Okay, so thank you, Vince. Brian, let me ask you, why did you decide to do juvenile dependency cases?
So I sort of touched on it a little bit just in terms of what I enjoy about it, but I think I originally just sort of became exposed to it because I started off in the practice of family law, which is very different. As I mentioned, it's governed by an entirely different code section. It's just an entirely different realm. And I started to have contact through that practice with juvenile dependency cases. The families that I were representing, I started having instances where they were running into the system and being sucked into the system. And of course, people would sometimes call the office with these sorts of problems, looking for a family law expert, or thinking they were looking for a family law expert when really they needed a juvenile dependency expert. And so as I started to sort of become exposed to this and just realizing how the system worked, I started looking into it, started studying it. And at the time I was actually working up in Northern California, not Southern California, with a boutique firm. And one of the partners of that firm had some prior experience in the field. So I told him I was interested in picking it up. He trained me in it, and I wish it was a larger part of my practice, but I'm very happy that I get to help families in it right now. Yeah, I would definitely jump at the opportunity to have more of these types of cases.
Did you ever deal with CPS?
Personally, fortunately, no. I've been. It can happen to anyone, of course. An investigation can be open just based on a misperception, a misunderstanding. In some cases, it can even be opened because someone someone's vindictive and they want to make an allegation that can launch an investigation. Of course, I think a lot of people and even a lot of attorneys don't realize the extent of the peril that can come from an investigation. And I'm thankful that I know how I would deal with it if CPS ever came to my door. But fortunately, I've also not had to exercise my training and experience in dealing with that.
Brian, when I was probably my 10th or 11th year of practicing law, and I had been doing, court-appointed work in LA County, I did get a knock at my door from a social worker. Did I ever tell you about that, Cynthia?
No.
Yeah, I got a knock at the door, and she was there to investigate me and my then wife, and with our 2 little children. And what happened was, my aunt was going through a divorce and told the counselor, get this, she told the counselor that she babysat my kids frequently, which was true, but she disclosed to the counselor that she and her husband had been participating in domestic violence, a few incidents of domestic violence. And from that, they came to investigate me and my wife. Had I not known anything about the system, I would have been really, really in trouble. But she didn't tell me, she wouldn't tell me where the referral came from, because I'm looking at my wife like, what'd you do? What did you do to the kids while I was gone? And I asked her, and she wouldn't tell me. But she told me, she said, the information is in that file, which was sitting on the coffee table. And she said, I'm going to excuse myself and go to the bathroom.
Oh.
So I looked in the file and I saw, the person's name. And then I saw my aunt's name. So after she left, I called her up. I said, who's this Dr. So-and-so? She goes, oh, that's my therapist. And I told her what happened, and she was surprised. But as a mandated reporter,
Right.
He felt that he should report me to DCFS in Los Angeles County.
Wow.
And they followed through with the investigation as well.
Oh, yeah.
They said, oh, this is worth looking into.
Right. And I told the lady, I said, look, when my aunt babysits, she comes over to my house, right? We don't pack up 2 kids and 2 bags and take them over there for, a 3 or 4 hour, babysitting thing. And sometimes it was all day. my aunt would come to my house and make herself at home, and my uncle, her husband, rarely saw the kids unless it was at a family get together, like for Christmas or Thanksgiving or something. So after that visit, they made a couple more calls and then they closed the case.
I think it's important to, for anyone listening in also to just kind of realize two things, and I think that story really exemplifies it. Number, the system really is designed to encourage reporting to an extent because you have these mandated reporters. And if there's something where there is any sort of potential child abuse or neglect involved, they're in a position where they can report it and it's out of their hands and they don't get into any sort of trouble. But if they don't report something and then somehow it turns into something, it's on them. They can lose their licenses, they can face criminal charges even. So we have this system in place that encourages these mandated reporters to report things that can be very even frivolous to CPS. And then I think the second thing that's really important that is just kind of revealed by your story as well is that when it can happen to anybody. People should not think, oh, well, I live my life well, I treat my kids well, there's no way they're coming to my door. It can happen. It can happen to anybody.
Hey, Brian, before I forget, I want to let the listeners and viewers know how to get in touch with you. If you could give us your phone number, your email address, maybe your website as well, so people, that are watching can say, hey, I want to call Brian up. So go ahead.
Yeah, thanks, Vince. I appreciate that. Absolutely. Yeah, if anyone is interested in getting in touch with my office, if they need representation or consultation, my number is 909-259-9908. My website is mayerlegal.com. That's my last name, MAYERLEGAL.com. I have links to contact me through that if anyone would like to reach me if they prefer electronic means as opposed to telephone.
What's your phone number? What's your office number?
Oh, that is my office number. I'm sorry. It's 909-259-9908.
Okay, perfect.
Yeah, thank you.
Are you working currently on any juvenile dependency cases?
Yes, I am, as a matter of fact. I took, just before COVID hit, I decided I really needed an extended vacation because my vacations were not vacations. And so I wound things down a little bit and I was actually planning to take an extended break. And then COVID hit and I said, perfect timing. So I went on hiatus for a while. I've actually just been I've been back. I was mostly closed. I still had some cases floating around. My doors are now fully back open again. But yeah, I'm handling. I do have just a few cases right now. And frankly, they're active. I don't know that my clients would be happy if I talked about any of the specifics on those cases right now while they're pending. So I'd rather talk about closed cases, I think, as opposed to ones I'm dealing with right now.
What's your most interesting closed case you ever had? Don't mention any names. We'll just talk about scenarios.
Right, of course. I think probably lots of them, but I think one that really stood out to me and just kind of shaped my perception of the entire court system, the juvenile dependency system rather, was I was defending, it was a couple who had a guardianship of about 8 kids or so. And it was an elderly couple. And the husband was accused of, by one of his female wards, of having had sexual contact with her. And the parents were absolutely, they were adamant that she was lying and she made the whole thing up. This was a 15-year-old girl. Their explanation was that she was, I'm sorry to say, she had problems, and she didn't want to live under the rules and deal with the parameters that they set for her. And she came up with this story to as her means of escape. And what was really interesting and rewarding about that, though, was that when we, and this was, and to be clear, this was probably my third year of practice, so this was absolutely one of my first cases, and it was. It was. I mean, I was only Vince. You know how it is when you're 3 years in. You're just you kind of know the rules. You can pretty much avoid malpractice, but you just don't have the skill set of a more senior practitioner. And so it was me against the government, basically. We went in when this was, we were able to call the girls a witness, and I say this, I don't know how to say this tactfully, but I tore her apart on the stand. It was, I did my best to kind of handle her with kid gloves in case, just being mindful of her age, and even if this was made up, she's just a kid and doesn't really know what she's doing. But her story was just so bad, and she just couldn't keep it together and just completely went to pieces. When the case was done, the judge went back into his chambers. He said he needed to think about it and go over some things. He came back out, and to my surprise, he didn't just say this, this is incredible. He told her she was a liar. He lectured to her that this was, you're going to damage a lot of people like this. This is the wrong thing to do. And what really stood out to me about the case was it taught me a lot of things. First of all, and I think I was probably 30 years old by this point, so still relatively young. And as I said, new in my practice. It taught me a lot of things, though. First of all, it kind of opened up to me this whole idea that you can have parents who are just genuinely, parents or guardians who are just genuinely innocent in their cases, and just brought into the system and their names slandered and just be exposed to the anxiety and everything that goes along with this. It also taught me that, frankly, the county just through this experience, it just really taught me that the county they don't have the inclination to prosecute these cases with the sort of integrity that you would expect. And by integrity, I mean the devotion to making sure that they got the case right, that they got their facts right, that they have a viable case. It was clear that they probably never talked to her more than just 5 minutes before we went in for the actual jurisdiction disposition hearing. And there's somebody ran their motorcycle outside. But what it really taught me is that if you have an attorney who is just genuinely dedicated to getting a good result, even if they don't have a tremendous amount of experience in that courtroom, they can win. It really just takes focus. It takes a genuine intent on protecting the clients. And even someone who is new to the practice can come in, defend you, and come out clearly triumphant, just because of lack of diligence on the part of the county sometimes.
How'd that feel when the judge, ruled in your favor?
That's a great question. And what I'll tell you is that I was so new to the practice at this point, I didn't realize the significance of it. It was I was just like, oh, okay, we won, great. I mean, I was very happy for the parent, for the guardians, but it didn't just the especially now that I've seen how it works, and I've been at this for a while. I've run into so many cases where the parents just get railroaded by the county and have problems with their representation. I didn't realize that at the time that it was particularly uncommon to for any given case, at least, for the parents to prevail. And something else is, I think that that was probably that was the first, my first few cases in that courtroom I won. And I didn't realize, I seriously didn't realize that for most parents coming in, they didn't win these all the time. And I remember going back and telling the partner who I told you about, I said, hey, we won again. And he gave me a big congratulations. I'm like, okay, whatever. Just not even realizing that this was like, the significance for, on a more macro scale of what it means when you can actually beat the government.
You do. Go ahead,
sorry.
Cynthia.
I just really fast, I wanted to input your contact information, so I apologize that we're going backwards. But it is Brian, BRIAN, at MAYERLEGAL.com, and the phone number is 909-259-9908.
Yes.
Okay. And then Vince, when you're ready, I have quite a few questions for him.
Go ahead. Go ahead with your question.
Okay. Let's start with, what can you do for a family versus the court-appointed attorneys?
So I think the main thing that a private attorney can do is just frankly give a case the proper attention that it needs. For the court-appointed counsel, you're just they just, I hate to say this, but you really are just a number. They just churn you out. They're not really interested in doing anything out of the ordinary, and frankly, they get paid the same. They get paid the same whether they take one case to trial or 1,000 cases to trial. And so there really is a degree of incentive for them to just not fight as hard as they could on some of these cases. And I don't want to put all court-appointed counsel into the same basket, because the fact is you do have different quality individuals who can take any given case. But that's also another benefit of private counsel, is that you can choose an attorney who is willing to fight for you and really examine your case and look for opportunities to get a favorable result and ensure that the law is being upheld, as opposed to just whoever they give you, and it's a roll of the dice.
I agree. I myself had a juvenile dependency case, and I can tell you the difference between a court-appointed attorney and a hired professional attorney, and there are significant differences. Vince, you were gone for a second.
Had to plug in my laptop. It was running out of juice.
Oh, okay. Okay.
And on that too, it's, for the most part, I think it's not an issue when it comes to court-appointed counsel. The issues that I hear from people is not really knowledge of the law. It's not that they don't know the law. It's just they just don't have the resources or the incentive to make sure that every case is done to its full extent. They're basically obligated to do the bare minimum, and that's fine sometimes. But if it was my case and if it was my kids, I would want to know for sure that when I went to sleep at night, I knew that I'd done everything I could for them.
Agreed. I couldn't agree more. Okay, the next question. Sorry, there's a lot of people that are commenting and writing things. People are talking about Tennessee. Let's see, here's a statement. Tennessee took my children because I didn't have a car or a job, but my kids still had what they needed. I was a single mom with no help. Passed all my drug screens and everything, and they still didn't give me back my babies. Let's see.
I think part of,
Go ahead.
I'm sorry, I was just going to say, I think part of the frustration that I have also with court appointed counsel is I see so many cases where people don't understand what happened from a legal perspective. They just, it's how can you, I have to ask, how can a parent possibly do what they need to do to get their child back if it's not been effectively explained to them what's going on and what needs to be done? And, you know, again, this is, I certainly don't blame any individual, but I feel like there's just more confusion from parents than I think would make sense if they were getting the proper explanation of what's going on.
I would agree. There's such a lack of education given to us parents when dealing with CPS right from the start that it makes everything very challenging. I would definitely say that. Okay, how do I find the license number for the caseworker for my closed dependency case?
So the way the question is structured, let me first assume that you know the person's name. That said, if you know the name, I only practice in California, but it's my understanding, I think every state kind of has its own standards and requirements in terms of licensing for any caseworker. So for any licensing, that information is definitely available through the state's website. It would be from whatever agency or department it is that issues and regulates the licenses. So the person trying to get licensing information for the caseworker in their state, if any, would probably, frankly, just do well to Google, you know, Tennessee caseworker license, and the regulatory board would come up.
Okay, thank you for that answer. What steps, this is from Callie, what steps do you take to get a case dismissed? I think this is kind of a big question, but what do you
it is a big question. It's kind of it's a question kind of like how do you pilot a Boeing 747? The question is certainly simple enough. The actual implementation of it is a little bit more complex. I mean, ultimately, if we're talking about dismissal, it's really it depends where you are in the case. It just depends on the procedural posture of the case. I'm sorry, Vince?
I think there was an echo.
Oh, okay. I'm sorry. I heard, my apologies. I heard something and maybe that was my echo. So the answer is it really just kind of depends on where you are, where your case is. Ultimately, if jurisdiction, I think what I'll try to answer generally, if jurisdiction has not been established, then its dismissal is by establishing that dismissal will generally occur if the county fails to prove that there's abuse or neglect. And if it's post-jurisdiction, well, again, it kind of depends where you are in the process, but it would generally be a dismissal would generally come about by showing that jurisdiction doesn't need to continue. So I wish I could be a little bit more specific, but the question's unfortunately just a little bit big.
What I usually tell people is it all depends. It depends on what module you're in. I've divided up, the Welfare and Institutions Code 300 section into about 5 or 6 different modules. And, each module, each hearing, there's a different standard, a different test, sometimes different burdens of proof. So when you want to get something dismissed, well, it depends what module are you in. What stage of the case are you in? And one of the biggest problems that I have is that someone will come to me in module 3 or module 4, and they want to rehash what happened in module 1. And it's the hardest thing to do to explain to someone is, look, you're in module 3. We can't talk about module 1 because it's really a waste of time. If you didn't appeal module 1 and win, it's over. It's done with. Well, Mr. Davis, I got screwed. They cheated, they lied, and blah, blah, blah. And the best thing I can do is sympathize with them. Okay, I understand. You're like most people that call me, but we're in module 3. Now, you want me to tell you how to get the kids back in module 3? Well, yes. Okay, well, let's stop talking about module 1. Let's talk about what we're going to do in module 3.
I think that is, I agree with absolutely everything you just said. I think one of the biggest, it's almost painful, like it hurts my heart, but I mean, you said it exactly right. From the attorney's perspective, I wish people could understand that the earlier and you have an attorney involved in your case, a good attorney who's giving you advice and helping you, the easier it is to resolve your case. The deeper you go into it, the further along you get, the harder and harder it is to change the trajectory of your case and to influence the ultimate outcome. So, yeah, I definitely agree.
Here's something I tell clients all the time, and I told Cynthia this, when I first met her. Do you want to win and get your kids back, or do you want to be right? Do you want to win or you want to be right? If you want to win and get your kids back, I can probably help you with that. If you want to be right and prove the social worker who's lied on you back in module 1, I probably can't help you. Because the amount of money you're going to pay me, you probably want me to focus on getting your kids back, not vindicating your name, from 3 or 4 or 6 months ago. The case has moved on. There are different stages, different modules, different laws, different tests, different burdens of proof. We got to catch up and focus on what's going on now. So I tell people that all the time. Hey, you want to win or you want to be right? And a lot of people think, well, isn't winning being right? No. No, no, no. On YouTube, I did a video. It's like a 7-minute video. It's called What is Justice? And I explained to people why their sense of justice doesn't equate to real justice in the courtroom. A lot of people tell me, this is what I think is fair, Mr. Davis. This is what I think is right. The problem is, that's not what the law says. So do you want to vindicate yourself and be right? Or do you want to win and get your kids back? Totally different things. And it's hard for a civilian, a non-lawyer, a non-judge, to accept that because they think that the courtroom is the ultimate justice of how they think of justice in their heart and in their mind. And if you've, not familiar with the legal system and laws and being a lawyer or a judge, that's not going to make sense to you.
Right.
Go ahead. What's your next question, Cynthia?
Okay.
looking at Facebook Live.
Yes. So I'm going through all the comments. While I'm going through those, let me ask you one of these that people wrote in. What am I legally, this is from Christy, what am I legally allowed to obtain from Children's Services regarding my file? Everything has to do with me and my children because they gave me a paper, but I have to request specific things that I want. What all am I allowed to get? I need to call you. I'm not sure if that makes sense. There's not a lot of punctuation.
It was a little bit, yeah, it was a little bit, the way it came across was a little bit rambling. I think what I was getting from that is what from, is this in the context of an open case or in just an investigation, or?
I believe it is open. So I think the question I'm seeing is, what am I legally allowed to get from my children, my file with a CPS case? And I think the reason that people are asking this is I've had a lot of people say, CPS will have me sign this paper, but I did not get a copy, or maybe the, minutes from the hearing, or so on and so forth. So what are they allowed to get from the file?
Sure. So
go ahead.
Was it an echo or? Okay, no, I was going to say I wasn't sure if it was an echo or something else going in. So what I'll say is, I mean, first of all, again, the rules are going to vary a little bit state by state in terms of what's available and what's not. If you're talking about a situation, though, where there is an open court case, you're going to have a lot more access to a lot more information than you would if it's just in the investigatory phase. Once the case actually opens up, there's something called discovery. Some of it is compulsory, some of it is available upon demand, and so in the court, at least in theory, the laws are written so that when the parties actually go to trial, there aren't any surprises. At least, to an extent, I say that with an asterisk, but for example, I mean, in California, there's really not an opportunity to perform something called depositions or other things when you get into the dependency cases. But you can have access to what I'll say is generally you can have access to most of the information and most of the file with as it relates to your case if a court case is actually open. And if you had a specific piece of information in mind, then you'd have to kind of have to evaluate that. Some information is protected, but for the most part, if you're looking for something specific, you can probably get it through if it's something that doesn't automatically need to be disclosed, then it's something that you generally have a right to demand. With California, there's actually, with our dependency courts, there's actually informal discovery that the county generally has to comply with. So it can actually be as simple, assuming you're represented by an attorney as opposed to representing yourself, it can be just as simple as your attorney just asking for the information from the other side. And for most items, it has to be provided. Something I'll say too is I think something that I would want to know, and I don't know if this is the right juncture to say this, but if I was a parent involved in the case, and if I felt like I just wanted to understand the system and I didn't have access, 24-hour telephone access to an attorney, but I just wanted to go out and read and learn about it, and I wanted to get it from someplace other than the internet. Something you can do is go to your county law library and pick up what are called practice guides. And actually, I'll just show you what it looks like. I mean, here in California, Vince, I bet that you probably have this one. If not by CEB, then by Reuters or one of the other main publishers here in California. But these things. Oh, I'm sorry. Well, here in California, this one is just called California Juvenile Dependency Practice, and we're in 2021. But this is my 2020 copy here, and it's a little bit legalese, but it's basically it's written in a way that if you'd never had access to the system before, what I'll say is pretty much every answer to every question is kind of in this book. It's kind of a thick book. I think I don't know what they sell for. I just don't remember. But you can go to any law library pretty much, and they'll have this or something exactly like it anywhere in the country for the most part. So if you're saying, oh, what do I do? Go to the law library. You can ask the law librarian and just say, hey, I want a book on juvenile dependency, and they'll bring you right to this, and they'll let you make photocopies out of it. Some libraries will let you check them out. You can take them and read them. So I would, if anyone's just like so thirsty for the kind of the technical, the detailed information, I would suggest considering going and taking a look at one of those if you have the time for it.
The book that he just held up is published, I believe, by the Continuing Education of the Bar, known also as CEB. That book you can buy in hard copy, and you can get it online. There's an online version that's actually searchable with links to the cases they cite or the statutes they cite.
What is it, Vince?
It's Continuing Education of the Bar. And what is it called again, Brian? Juvenile Dependency Practice?
Yeah, and you're right. It's Continuing Education of the Bar. It's CEB. This is, if you're in California, which obviously a lot of us are, this is the specific book, California Juvenile Dependency Practice by Continuing Education of the Bar, CEB. This is the book that I would recommend for that kind of extensive, any question you might have to ask, detailed answer.
Thank you. Hold on,
I love the online version.
I have not seen the online version. It's never crossed my mind. So now that you've said that, I'm going to have to look. I think they should be paying us royalties for this. What do you think?
Vince, why do you suggest the online versus
the book?
Yeah.
Look how thick that thing is. You don't want to be carrying that around all the time. And I think at one time they were actually divided up into two different volumes. But that book is online, and what makes it really good is if they cite to a case or they cite to a statute, you can click on it and go right to that case. See, if you have the book and they cite to a case, you got to go look it up. If they cite to a law, you got to go look it up. But with the online version, you can click it and go right to it. But the other thing is that it's searchable. Like you want to search for something on Google. Well, this you can search the online version. So that's why I like it. And then I'll have it anywhere that I am.
How do you purchase it online? Is it through?
You just go on to CEB. It makes it look like you have to be an attorney to buy it, but that's not true. Anyone can buy it. So what happens?
Glad you said that.
The other thing I like about it is, I have my laptop all the time with me, or my mobile or my iPad, and wherever I am, I can pull up that treatise or that book. So sometimes I'm doing the radio show, and I'll have my laptop, and you think I'm doing something on it. Sometimes I'm looking things up on CEP, Juvenile Dependency Practice.
That whole time I thought you were sitting there scrolling through Facebook.
Right, I wasn't.
Okay, another question. How to turn in the DCS workers and the judge that made the decision knowing my kids were being harmed while the case was still open?
How to turn them in, is that the question?
Mm-hmm.
Okay, well, I mean, I think first and foremost, when it comes to judicial misconduct, every state has an oversight board. Any complaints of judicial misconduct can be investigated by the state. But if you're talking about a situation where a social worker, I mean, if it depends exactly what's happening. If they know that the child's being harmed, if they're allowing the child to be harmed, then there can be criminal consequences. And in which case, if that's the case, then at least theoretically, law enforcement would be the agency to perform that sort of investigation. But in terms of, and Vince, definitely please chime in if you can think of any additional information here. But as it relates to the social workers, simply not performing their job, if you're talking about outside of a criminal context, then they work for the county and they have a job with the county. And if they're failing to competently perform their job, they're accountable to their bosses, and their bosses are accountable to elected officials, and the elected officials represent you. So there's not like a special court that evaluates specifically caseworkers who fail to protect the kids that are part of their caseload or anything like that. It's just kind of the nuts and bolts of the larger system. There's law enforcement, there's the county government, and it just kind of depends on what exactly is going on in the case.
So, the number one thing that you can do is you can vote. Vote for family-friendly judges, vote for legislators that will make family-oriented laws that will protect parental rights instead of taking them away. But here's what I've been telling people a lot in the last year or two. The Department of Health and Human Services has a complaint system where you can file a complaint against any social worker or social workers in any county or state who you believe are violating the rights and the rules and regulations of the Department of Health and Human Services. Because DHHS is the seed, is the overseer of all social workers in the country. So you can make a federal complaint, administrative complaint. The other thing that you can do is you can make a federal administrative complaint to the United States Department of Justice Civil Rights Division. Now, in the past, people thought that nothing would really be done. But I'm here to tell you from personal knowledge that these folks from DC or from wherever they're from, they assign expert social workers, they assign psychologists, and they go through these cases with a fine-tooth comb if you are alleging wrongdoing. All right? Now, if you have something that's rambling and you just submit it, maybe you won't have a good enough chance. So maybe you want to have someone help you fill these complaints out. But on many cases that I have, that I personally work on, if I think something is being, done that's not correct or not fair, or violating someone's rights, I recommend to my clients, I tell them, here's the link, because the complaints are all online. You can do it a PDF or online complaint, fill it out, and, wait for someone to contact you. And people do get contacted. I have a case in another county up north where the investigator contacted me. It wasn't the investigator for the federal government, it was the investigator for the county. Now, I don't know if you know this, but each county has a small group of workers that do nothing but monitor to make sure people's rights aren't violated. Because the penalty to the county, if the federal government finds that you have violated someone's rights and it caused substantial harm, the penalty to the county is substantial and it's monetary, right? Everybody cares about the money. So even the counties try to monitor itself, even though sometimes I get the feeling that it's just, we're doing it, so, we're taking it seriously where they may not be taking it seriously. But I was personally contacted by someone within a county agency and asked specific questions about what had happened in the case and why I thought something had been done wrong. So they were they were jumping ahead of the federal government to try to get their ducks in a row before anything happened. I was telling someone this the other day. There was a case where some wrongdoing had been alleged. And the federal government, the Department of Justice, the Civil Rights Division, and DHHS combined. They combined and did a joint review. By the time they finished the review and the report, the kid had been adopted out by foster parents, non-related foster parents. So the federal government told the county, it's too late for us to do anything. The kid's been adopted out, right? But since the kid has been adopted out, and if the kid doesn't end up back with his family, we're going to stop your federal money, or a large part of the federal money. Within 2 days, that kid was back with the family. Someone told me, a judge once told me in another county, I don't think money has anything to do with this. And I thought to myself, money has everything to do with this. They wouldn't be doing this unless they were making money. They wouldn't be doing this unless the federal government was funding it. Yeah, we're trying to protect kids. But, some of these cases I see, I think to myself, why are we even involved in this? Why is CPS even involved in this situation? Mom and dad got into a fight over the weekend. The kids were at grandpa's house, and now they're filing a case. Anyway, enough of my rambling.
I appreciate that information. That's I appreciate that. That's another. I'm definitely interested to. I don't handle the complaint side of things. I get lots of questions about how to complain, and I tell people what I know, and that's where I leave it. So, but I appreciate that. Thank you.
Really fast, I found the book online, and if you want the online version, it's $245, and the printed version is $255.
Hey, Brian, you know what I like about the online version too?
What's that?
It updates automatically.
That is nice. So is it an annual subscription or?
Yeah, it's an annual subscription.
Okay,
So
that's
I
great.
guess I pay the $235 a year, right? But think of the return on investment on something like that.
I'll tell you,
I can always be an expert.
I'll tell you what though, there's the reason the reason I prefer the book is because I stare at a screen all day, and if I can turn away from it for a few minutes to look something up, it's just I think I'll live a little bit longer at the end. So but no, you're absolutely right. It's I think you know I've worked with Westlaw and LexisNexis before, and being able to just click on a link and get the citation is can definitely be nice.
Mm-hmm, mm-hmm. Any more questions?
There's a few. Just a moment. And there's some good ones. So, how do you prove emotional trauma to children if courts do not want children to testify in court?
When they say you, I think, are they asking you about proving how would the county prove it? Is that,
how can someone prove emotional trauma?
Sure. You know, I guess what I'd basically say is, you know, proving things in court it's a lot like proving things in life. Like, you know, if you ask the question, I mean, how would you prove that you went to the grocery store today? You know, you maybe have a receipt, maybe someone saw you there, there's security footage, maybe a police officer stopped you because you're speeding outside the grocery store. You know, maybe charging your credit card, and you probably have some some fresh groceries in your trunk. And the fact is, when you're trying to prove something, um, when you're presenting evidence to prove something, it's kind of like a jigsaw puzzle. It would be ideal if you have all of the pieces there, but most of the time there are going to be pieces missing here and there. But as long as there's enough there to be able to look at it and understand what the picture is, then you can meet your burden of proof. So sometimes it requires creative thinking. Sometimes you can, depending on the situation, maybe you need some expert witnesses or private investigators, or maybe subpoena some information to get it. But it's not, proving something is not really, it's not really magical. It's just being able to have access to the tools to get you the information that is available to help prove your case.
Cynthia, who was the name of the person that asked that question? Or what was the name?
Tara.
Kara?
Tara.
Tara. Tara, I like your question because it highlights a problem between a lawyer and a civilian. In reality, you can't prove it unless the kid gets on the stand. Now that's reality. But the courtroom is not reality. It's a stage, it's a theater. And it has its own rules of evidence that are in the evidence code and in our case law here in California and in every state. So this is what I was talking about earlier. Don't look at these cases with common sense, because you'll always be frustrated, because common sense doesn't always play or isn't always used in making decisions in these cases. The state legislators and the appellate judges in our state tell us how to prove emotional abuse without putting the child on the stand. It's like making a chocolate cake. There might be 3 or 4 or 5 different recipes. Just because the one you use doesn't mean it's the one they use in court. So common sense sometimes has very little to do with what goes on in any courtroom, not just a CPS courtroom, in any courtroom. Okay, so I agree with her. How can you do that? Well, reality can't, but we don't, we're not using reality in courtrooms. Any other questions?
Yes. Can I sue CPS for not allowing me to visit my grandson? I think this one's vague and also depends on, because I feel like I could answer this not being an attorney just by listening to you, Vince, but go ahead.
No, tell me what you think the answer is.
Well, my answer is going to be based on whether or not your child has rights, number one, because what I've heard from you is that if my child loses their parental rights, that means I no longer have grandparent rights unless I have been given, 1 second, son. I forgot what you call it, but basically some form of guardianship as another parent in the case. But that would be my answer. And this question's from Shannon.
Okay, Shannon, you probably can't. Now, I hate to tell you that. I was raised by my grandmother, and the law sometimes gives less rights to grandparents than they do to the actual parents. And I'm familiar with some cases where they were righteous cases in my mind, and they were kicked out of court because grandparents don't enjoy the same rights to children as the parents do. You have to sue them for different things. Then you can't go into court and say, hey, I'm a grandparent. You took the kid away from me. You didn't let me have visitation. You have to say that your rights were violated in some other way to try to survive. So it's clear that parents can sue for violation of
I
rights.
missed that word sue. I was answering as if it was, can I visit? Can I see my grandson? Can I sue? Sorry.
Now, she can go to juvenile court and file a 388 petition, or a presumed parent petition or a de facto motion and try to get visitation or custody. But I thought she was asking, what can she do when the social workers won't let her do that?
Right. No, she asked if she can sue for them not letting her have visits.
And the answer is probably not, but I'd have to hear the facts.
Right.
Brian, I don't know if this ever happens to you, but somebody calls you up and they're talking to you for about 5 or 6 minutes and they say, can I win? And I usually tell the people, I don't know. We've been talking 5 minutes. How can I tell? Haven't seen one piece of paper, 1 minute order, one document, one transcript. Haven't talked to any of the attorneys. I don't know if you can win. It's just, I don't have enough information.
I explain it that when I'm presented with that, and this is, of course, in this case, it's really a one sentence, not even 5 minutes. I have one piece of one half of a story involving people I haven't met, a case file I haven't seen, and a court, a matter I have not spoken to anyone on. And if I gave you an answer, I wouldn't listen. If I were you, I wouldn't listen to it.
And when I tell people that, a lot of people get upset with me. A lot of people. A lot of people call me, tell me a story in 5 minutes and want me to say to them, you got a winner. You got a winner. I can't say that. I tell them all the time. They'll tell me something like, well, attorney so-and-so told me that we could win. Well, you could. That's not you would. But you haven't given me enough information to determine, what your chances are. Let's explore this a little bit more. Do you have any documents that I can review with you? It's a very difficult thing. And people, we're talking about people's children. what else? I mean, highly emotional, highly upset. I used to answer the phone, someone would call for me. Say Cynthia would call me, and, she's going to be a prospective new client. And I go, hello, how are you today? Or how you doing? And in these cases, that's probably the wrong thing to ask, right? Here's some poor lady. She doesn't have her kids, or they were just taken away last night. Like, how do you think I'm doing?
Right.
I usually start off and say, give me the 30-second version of what's going on.
Oh, that's good. I like that.
Well, and people usually adhere to it, so at least from there you can ask the questions, because they don't know what's important. And they have all this information, so that helps everybody just kind of focus, so you can at least start to identify the issues.
Now, Brian, there are still a few questions. Some are actually titled specifically to you. I did tell you 8 o'clock. Did you want to?
I'm having lots of fun. I do have a little bit of an obligation, but I gave myself a little bit of cushion room just in case I was having so much fun. So let's let's pick out 2 questions, and then
Okay.
I'm unfortunately going to have no choice but to wrap up for this evening.
Totally understand. And right now we have a great audience, just to let you both know.
Oh, good. I'm so glad.
Okay. This is from Brenda. Brian, have you ever won a trial where the parents, oops, sorry, hold on, my computer is, I'm sorry, 1 second. My computer is like freezing. It's been doing this lately. Oh my goodness.
Yeah, and you're a little bit choppy too.
I'm sorry.
Give it a second to maybe catch up.
Yes, it's like, oh my gosh. I might have to open it up on my phone. Let me do that really fast. I think because so many comments are coming through right now, like it's blowing up.
Well, I'm really glad that people are watching, because this is such important information.
Yes.
And yeah, I definitely, I didn't realize that Vince was going to be on tonight. I'm really, really glad I got to interact with him here. So Vince, thanks for being here with me. I appreciate it.
No problem. I'm going to be calling you, talking to you about possibly working together.
I would love to explore that.
Okay. Here we go. Brian, have you ever won a trial where the parents refuse to comply? They can present evidence to prove they didn't deserve the kids removed in the first place. Would you say that after the kids are removed, to get them home, do the parents have to agree to a safety plan?
And I know it's difficult because people are sometimes typing and sometimes having punctuation problems and other things. And it was a compound question too, so that made it a little bit hard. I'm going to be honest with you. I think I need it read again.
Okay. Have you ever won a trial? That's a question mark. And then.
Oh, that's a question mark. Have I ever won a trial? Yes, I've won a trial.
Okay. And then this says where the parents refuse to comply, they can present evidence to prove they didn't deserve the kids removed in the first place? Question mark.
Okay, so the question is whether the winning at trial where the parents were able to prove that the kids did not need to be removed in the first place. I think that's what's being asked.
I think so.
Okay. Well, I think first of all, the important thing to recognize is that it's actually not the parents' obligation to prove anything. It's the county's burden to prove that the children need to be removed. So I think the first thing to understand in answering that question is technically you can go in as a parent and technically you can prove nothing. If the county fails to prove their case that the kids need to be removed, then the kids have to be returned. But you know, I would say, I mean, essentially, that's pretty much when you win at the jurisdiction disposition hearing. That's the hearing where basically the county has to prove that the child falls under the jurisdiction of the court. That is that uh, the allegations that are made actually should be sustained. Um, Pretty much anytime a parent prevails at that juncture, it's because the county was just able to not put forward the evidence that sufficiently put forward the evidence that there was a basis for removal in the first place. Now, I mean, technically the county can, technically the county could, there could be I suppose there could be a basis initially, but then that basis goes away by the time it gets to trial. Uh, there's no reason that that really couldn't happen. But yeah, it absolutely, you know, yes, that happens for sure. And I'm sorry, what was the rest of the question then?
It is lost in the
Oh,
comments are blowing up right now.
oh, I'm sorry. Okay,
It's okay.
now I understand the problem here. Okay.
Um,
Um,
here's a good one. As a
okay.
parent who grew up in foster care, how can CPS use a parent's trauma against them as a reason to take their children away? And this is something I hear all the time is I would say 90%, 85 to 90% of parents that have a CPS case now were a victim of CPS as a child.
Yeah, and this just sort of, in my mind, this sort of underscores the importance uh, of exercising your right to not talk to the social workers or the police when these cases open. Because truthfully, I mean, everyone has seen the television movies. The police will say, you have the right to remain silent. Anything you anything you say can and will be used against you in the court of law. It's true in these cases as well. Folks who do have a right to remain silent, they should exercise that right to remain silent. Their silence cannot be used against them, and there's not literally nothing that you can say to help you when you're being investigated. Um, if they think you've done it, the absolute best you can hope for is that nothing you say will hurt you. It cannot help you. And usually anything you say will end up getting turned around on you. But I mean, ultimately what it comes down to is, I think, generally when a parent has some sort of history that feeds into sort of a narrative of who they are, whatever kind of troubled past they have, and they use that to sort of create a narrative about what kind of person they are now. Truthfully, for the most part, a lot of times it really is irrelevant. It really is irrelevant, and the court should not take that in. A lot of times, should not take that into consideration uh, when um, when deciding whether or not the allegations are true or not. But how it can be used in any specific case, you'd have to look at that specific case to see how it somehow became relevant to what was going on in that case. But I'll agree that for any given situation, some sort of trauma that happened to the parent in the past really does not, uh, for the most part, does not give us any insight as to whether or not it's appropriate to have their child removed today.
Well, thank you. That was a great answer. Okay. Do you want another one, or do you want to?
Let's do one. The first one will only count for half, so we'll do one more, and then unfortunately I think I'll have to. Fortunate for the audience, but unfortunate for me, Vince will have to maybe take over then and do it solo to wrap up.
Okay. Can a judge deny the return of children if the social worker wants to return the children and has no concerns after 15 months? Sorry, it's not letting me go down again.
Well, I mean,
go ahead. I'm sure you can answer it from there.
Sure. I think I know what's being asked. I mean, ultimately, what it comes down to is the social worker is going to take the position of the county, and the county is the one that is filing the position and advocating for any specific outcome. So, you know, I guess if once the I can say this, I mean, the court does not have to take the recommendation of or the request of the county for any given case, but it's pretty it's at least as it relates to anything sort of macro as opposed to micro. It's pretty unusual that I'm not sure if the questioner has anything specific in mind, but you know, basically, yeah. I mean, if the county is not advocating for the parent to have some sort of rights restricted or some sort of limitation, I guess it kind of depends, because I mean, in some cases the court's not even going to have jurisdiction to consider it. You know, I can say I had. I mean, I actually did have one case where we had struck a deal with the county about how about continuing services for the parents, and the judge basically said, no, I'm not going to accept that. We need to, you know, this is I'm not accepting that we're going to strike a deal. We need to hear the evidence, and this is going to go to trial. So it's I have to. I'm really trying to answer as best I can. It's just I'm where I'm struggling is whether the assumptions I'm making about the question are correct or not. I think what I'll have to do is just say generally, for the court will only be able to grant the relief that is being requested by the county, which would, again, the social worker is going to represent the county's views, but so that's kind of, so if the county is not asking for it, then in most cases, in most circumstances, the court's not going to have a reason or a basis for taking something away from the parents. So I wish to whoever asked the question, I'm sorry the question's a little bit more fuzzy. I wish I could talk to you and get a little bit more information.
Yes.
That was a terrible answer. That was a terrible answer. Vince doesn't want to work with me anymore.
Oh, no. You know what you could do, Brian, right now, give us your number and your email address that some of these listeners can contact you. I know he did earlier. Give it again.
And I put it in the comments as well.
Oh, you did? Okay.
Yes.
Oh, great. Wonderful. That's probably what's best. So.
Yes.
Okay. Well, that answer is so clumsy. Now I want to do one more so I can end on a positive note.
Okay. Let me see.
I'm an attorney, not a radio personality. Sorry, folks.
Speaking of radio, I don't know if we have invited you or not, but I want to give a personal invite to our radio show with me and Vince. It's on KABC, which you can see behind Vince right now, and it's on Saturdays from 7 to 9. That's our normal time. So if that's something that you're interested in doing, let me know and I will give you more details over the phone.
I appreciate that invitation. Saturdays are a little bit tough for me, but if the opportunity becomes available, I'll let you know and see if you're still interested. Thank you.
Great. Okay. Let's see. If you are in a TPR petition, typically how long does it take for the case to be resolved? Like, can CPS continue to delay the case due to COVID, where it leads to termination of parental rights on Zoom? Because I am still dealing with them for 2 years and they are still delaying.
Well, and so for anyone who's listening, TPR, and you said it, but for anyone who's listening and has not gotten to that stage in their case yet, TPR is termination of parental rights. And this is basically the last thing that can happen in a case. It's the grim reaper of the case. It's what basically kills it for the parents. At that point, the county has made the decision that reunification is not possible between the parents and the child, that whatever issues gave rise to the county's taking jurisdiction in the first place cannot be resolved in a way that leads to reunification. So, basically when it came down to COVID, COVID definitely threw a monkey wrench in everything. The courts were, depending on where you were, the courts were closed for anywhere from weeks to months. Then they were open certain days of the week and limited hours, and then they were open and then they were closed, and it was creating this, while this was happening with the courts, and then of course once they opened again too, to the extent they were open, the process was slowed down because now we're dealing with social distancing and oftentimes technology issues and just various problems. So, ultimately what came down to is it's a historical disaster. And, it's like if a meteor fell out of the sky and destroyed the courthouse, you're not having court that day or that week. It's going to cause delays. So COVID created really a very, very special circumstance that allowed a lot of cases to just not to be delayed, to not drag out, and to whether or not it was lawful in any given case, it would have to be evaluated. But for the most part, it just caused everybody delay, and frankly, we're still to an extent feeling the effects of those delays. I do think it's important to say, though, that if you're dealing with a termination of parental right, if you're at that stage of things, to be perfectly straightforward, it's usually if it's to anybody's advantage, it's usually more to the parent's advantage for those delays to come into effect. And it depends. It really depends. But if the parent is in a situation where they have some sort of issue, like maybe it's a drug problem, or they're coming back positive with testing and they've not completed classes, or whatever it is that led to the county's determination that parental rights, it's appropriate to terminate the parental rights. Once you get sort of get toward the tail end of things, and they're talking about terminating services and terminating parental rights, usually if it's that bad, then if the parent can buy some time to try to get things back on track for themselves, or to correct whatever perceived problems there were, or just basically give them a more favorable set of facts to work with, then it's usually to the parent's advantage. But naturally it's going to have to be looked at on a case by case basis. So I'm really sorry to the person who asked the question. They've been just dragged through this hell for so long. It's I can't imagine personally going through it. And you know, I look at cases like this, and I don't know how people do it. I see it, and I don't know how people manage to keep themselves together for it. I think a lot of people who are going through it do a lot better than I would if I was in their situation. But it's you know, but yes, COVID has created some special circumstances, and one of those special circumstances is that it has created lawful delays that otherwise would not have happened, or frankly would not have been lawful to happen.
Yes, I agree. And you know, having gone through this myself, it is very difficult to keep yourself together. I have my faith that I held on to, and then after, you know, obtaining Mr. Davis as my attorney, I had hope, and I felt like I had a wolf pack protecting me, you know. So I want to extend from everybody who was listening and putting on their gratitude for coming on and sharing your wisdom. Thank you so much for doing this. We loved having you as a guest on our show. Your answers were awesome. You were an amazing guest. Thank you for all that you do. And Vince, do you have anything to add?
We'll see you Thursday at 7 p.m.
Thursday where?
Right here.
Oh, sorry.
Not
Yes.
Thursday, Tuesday.
Yes,
Tuesday.
Tuesday we have another guest. So come back on Tuesday for all that are watching, and we will post who our guest is. So.
And this Saturday, check us out on 790 KABC in Los Angeles, AM Talk Radio. And if you're not in the LA area, go to kabc.com. You'll catch the live simulcast of the radio show. It's broadcast nationwide.
And you can also watch it on the Facebook page, The Secret, How to Fight CPS and Win. And if you have questions and you want to get those questions answered, you can call in at 1-800-222-5222. If you have any questions or you want to be interviewed and share your story, go ahead and message this page